engaged. On the horn. Hartford. OnTheHorn.com.
All right, you're listening to News Talk tonight. I'm Dave Moore, your host. Unfortunately, Jen Just is not with us tonight, but that's okay because she's doing important stuff, with the family, which, I support. Well, tonight we have a few stories that are of interest. One, a judge found that Governor Rell's firing of a developer was wrong. Linda McMahon had released her 2010 tax returns. Turns out that she was only paying a tax rate of 15.3%. Susan Bysiewicz ran an attack ad that happened to be inaccurate, but it's still playing. And let's see. Oh, yeah, the administration has started putting away money to the rainy day fund. Apparently, we're making enough money to do that. A women's group has targeted Chris Donovan, and the death row legal team seeks to argue the abolition for all of the death penalty. Not just the new guys, but the old guys, too. Should be interesting. Well, we start off with the lawsuit that was started as a result of Governor Jodi Rell firing a developer for the Front Street development. Superior Court Judge Marshall Berger has found that former Governor Jodi Rell was wrong to fire the developer of the Front Street development, a part of former Governor John G. Rowland's much-plagued Adrian's Landing development. The development includes the Connecticut Convention Center and the Connecticut Science Center. Those are two projects that have actually succeeded. The developer, Capital Properties, was fired because it refused to sign a second or amended contract, which would have reduced the responsibilities that the state had agreed to in the original contract. These news stories, by the way, have been purloined with permission by ctnewsjunkie.com. The particular author of this particular article is Christine Stewart. I've, of course, added my own embellishments. Former Governor Rell's administration had just come into power due to former Governor Rowland's abrupt resignation on July 1st, 2004, due to corruption charges, when the Rell administration issued an ultimatum to Capital Properties on July 26th, 2004, to execute the amended contract or face termination. Capital Properties determined that the amended contract was not in its best interests, and since it had a valid contract already in place, it refused to sign the amended contract. According to the decision, which was published this last week, in a lawsuit filed by Capital developers, the state claimed that Capital repudiated the terms of the original contract by failing to sign the amended contract and by abandoning the project in the early winter of 2003 into 2004. The project has been vacant ever since that time. Judge Berger concluded that, quote, "This court finds no support for these arguments," end quote. Capital was found to have spent thousands of dollars on the project right up to the time that it was terminated. The state claims that Capital has been reimbursed a balance of $1.2 million, but that figure has not been determined by the court, which will hold a hearing and damages proceeding in the relative near future. And what the state was saying was there was basically $5 million that had been spent, and Capital was reimbursed for about 3.8, leaving a balance of $1.2 million. Just wanted to make sure that you folks were clear on that. The court found that, quote, "The state breached the agreement by unilaterally demanding that Capital sign the proposed Second Amendment on July 26, 2004, threatening to terminate Capital if it did not sign the amendment, and terminating Capital because it did not sign," end quote. The decision could end up costing the state of Connecticut millions of dollars. In other words, more than the $1.2 million that is still owed to Capital Development. The state has also already paid a law firm, Halloran and Sage, $3.1 million in legal fees to defend itself, and still owes the firm about $14,000, according to attorney Perry Zinn Rothorn, who is an associate with the firm. Andrew McDonald, Governor Daniel P. Malloy's chief legal counsel, said that the conflict or problem described in the lawsuit came under the Rowland administration. Management of it spanned the entire length of the Rell administration, and now the Malloy administration is left cleaning up the mess. Said McDonald, John Rowland's legacy to the state of Connecticut was not only corruption, but apparently incompetence as well. End quote. On to politics. Linda McMahon, one of two Republican candidates for the United States Senate seat being vacated by Joseph Lieberman, independent, released her 2010 tax return this last Friday afternoon after being hounded by the media to do so last week. Tim Murtaugh, McMahon's communications director, said that they decided to release the 2010 returns because they're afraid the 2011 returns won't be completed before the August 14th, 2012 Republican primary. The 2010 return, which McMahon filed with her husband Vince, showed that the couple earned about, get this, $30.6 million. Most of it was dividend income. Aside from the $827,500 that good old Vince took in from the WWE as president and CEO of the WWE, and aside from $155,000 that was earned by Linda McMahon when she produced a movie with her son and daughter-in-law, the balance, which is about $29.6 million, was dividend income. That income was taxed at the rate of 15%, which means that the McMahons paid a federal tax rate of about 15.3% when you add that all together. They actually paid about $4.7 million in federal taxes in 2010, and the 15.3% rate was the lowest rate of all of the U.S. Senate candidates. The McMahons made personal charitable donations of $122,000. That's what was reflected on their personal return. But they also made $1.6 million in charitable donations through the Vince and Linda McMahon Family Foundation, including $1 million to Sacred Heart University, $100,000 to the Boys and Girls Club of Stanford, and $333,000 to East Carolina University, where they attended school and where they met, and $25,000 to the Stanford Hospital. The other Republican candidate, former United States Representative Chris Shays, has been critical of McMahon for not releasing the returns earlier. He says he does believe that she does not have control over how quickly third-party reports are made or when the returns get to be completed. United States Representative Christopher Murphy, Democrat from the 5th, who is the Democrat contender, along with Susan Bysiewicz, for the Senate seat, took the opportunity to criticize McMahon and her campaign's proposal to lower taxes for the middle class. Said Murphy, like many voters in the state, we're interested in seeing the details, but this certainly explains why McMahon is pushing her tax plans so hard. Ben Martyr, spokesman for the Murphy campaigns, was actually the person who gave that quote, said, Martyr, she stands to benefit 10 times what the average Connecticut household would under her tax plan. Murphy, the Democratic frontrunner in the Democratic primary for the seat, and his wife earned about $220,000 in 2011, with an effective rate of 22%. By the way, according to the news report, Murphy and his wife used TurboTax and used the TurboTax program to file their taxes. On to the Democratic primary of the Senate seat. The other Democratic contender for the Senate seat being vacated by Joseph I. Lieberman is Susan Bysiewicz, and she has admitted that aspects of a television advertisement put on by her campaign attacking Chris Murphy are incorrect, but she has no plans to pull it. Murphy has asked through his lawyers that TV stations pull the ad, citing a federal law that prohibits false advertising. The TV stations have fired back that they can't pull it because under federal law, they have to run the ads presented by candidates, whether they are accurate or not. Murphy also called the admission by Bysiewicz sad and a little frightening. The comment came after the last televised debate this last weekend between the candidates. It's the last televised debate before the August 14th primary. The TV stations have stated, as I said, that they will not pull the ad. Murphy's lawyers are contending that it really is prohibited advertising. The at issue is a 30-second commercial focusing on campaign contributions that Murphy has taken from Wall Street donors since being elected to Congress. That means, folks, since 2006, like for the last 6 years. The ad and a website launched to accompany it incorrectly classify several donors as Wall Street contributors, and the most glaring inaccuracy of Bysiewicz's statement is that Murphy has taken more money from hedge fund donors than any other Democrat in Congress. Bysiewicz said that the statement was incorrect, but the ad will remain on the air because the general point that she was trying to make still holds true. Chris Murphy has received significant financial support from Wall Street donors to the tune of about $700,000 since 2006, and has voted for their interest, she claims. Bysiewicz is referring to a 2010 vote in which Murphy voted against legislation which primarily extended unemployment compensations before being amended to offer tax breaks to specific populations, the hedge funds. The bill also changed the treatment of carried interest, which is the main source of income for hedge fund managers. Said Bysiewicz, the ad is incorrect. He's number 4 in terms of hedge funds. He's not number 1. I point out in the ad, and this is the main point of the ad, that he has taken huge amount of money from Wall Street and then supported their loophole. Said Murphy in response, people have been searching for a difference between the two of us over the course of this race, and that difference may be emerging. Susan will do anything and say anything in order to make this race more competitive, including running an ad that her own campaign acknowledges as false. End quote. Wall Street reform has been a primary focus for Bysiewicz throughout her campaign, and especially in the last debate. She used several opportunities to attack Murphy for the 2010 vote. Murphy did not counterattack, but focused on jobs being his top priority. And he indicated that anyone who is going to elect a U.S. senator whose priority isn't job creation is making the wrong vote. I love politics. The next piece of news is something that is both good and bad. Also from Christine Stewart. As the state's budget picture improves, Governor Daniel P. Malloy's budget director Ben Barnes said in a letter on Friday that the state will set aside about $102 million for the rainy day fund. Now, this is a rainy day fund that has been in existence since Governor Rowland's time. During the last economic downturn, starting in 2007 into 2008, into 2009, into 2010, etc., we used the rainy day fund in order to basically balance the budget. This will be the first time in 2012 that the state has sought to begin to replenish the fund which was depleted at the beginning of the recession. Even though the state still technically has a deficit of about $120 million, revenues have improved by about $72 million, according to Barnes. At the same time, in order to balance this year's budget, the General Assembly agreed to postpone using $220 million in funds earmarked to pay the borrowing it did in 2009. The additional money it saved by not paying down the borrowing it did in 2009 is what will be used to reopen a rainy day fund. This is an important step toward rebuilding the reserves as a contingency against the next economic downturn, Barnes wrote in his monthly letter to State Comptroller Kevin Lembo. Over the past month, Barnes said that the revenues have been revised upward by $56.3 million, including $16 million in personal income tax, $15.2 million in inheritance and estate taxes, and $13.5 million in licenses, permits, and fees. Spending has also decreased by about $15.7 million since the last month, but is still running at about $6.8 million over initial projections. One of the things that the General Assembly also did at the very end of their last session was to vote to take the surplus that the probate system has generated over the last year, almost $2 million, and plunk that into the general fund. The whole reason why we did the probate court reforms was because they were starting to lose money. And in particular, smaller towns were really running in the red. And the idea was that we were going to make the probate system more fiscally responsible and better capable of dealing with its needs. It did. And in 2011 into 2012, the fiscal year of 2011, they ran somewhere between $1.1 and $1.5 million in surplus. That got transferred over to the general fund courtesy of the General Assembly. Republicans have been critical of the decision to use the money earmarked to pay down the borrowing that the state did in 2009. Calling it a gimmick, they said that it will hurt the state's Wall Street credit rating. The diversion of these funds to finance operational expenses is fiscally irresponsible and will lead to another downgrade by the agencies and ultimately higher interest rates on future bond issues, said Senate Minority Leader John McKinney and House Minority Leader Lawrence Cafaro in a letter to the governor in May. Barnes, however, disagrees. Our efforts to prepay the economic recovery notes didn't carry much weight with the rating agencies, Barnes said. Moody's Investor Services downgraded Connecticut's rating from a AA2 to a AA3 in January, noting Connecticut's, quote, high combined fixed costs for debt service and post-employment benefits relative to the state's budget, pension funded ratios that are among the lowest in the country and likely to remain well below average, and depleted reserves with slim prospects for near-term replenishment, end quote. So it is Barnes's argument that with that last little item, the depleted reserves are having refunded the rainy day fund actually will help improve the bonding situation. The administration has maintained that establishing a rainy day fund will help ready the state for the next economic downturn, which is interesting because we haven't quite come out of the first one to begin with, and will be looked favorably by the three credit rating agencies. I have a tendency to agree with that particular assessment, but I think that we actually need to do a little bit more other than just basically the financial shell game that previous administrations engaged in that got us to the point where Governor Malloy was dealing with a $3.2 billion deficit in 2011. What is interesting is the Republicans continue to carp about the financial gamesmanship, as they would like to term it, in order to prove the point that nothing has changed. What they ignore is the fact that the governor was able to take away a deficit to the tune of $3.1 billion. And we have what is left really is, about $120 million in the hole. Well, that's the .1 that I was saying hadn't quite been wiped out. Tune in as we continue to take a look at the state and how it is trying to deal with the deficit, because that's actually going to be a big thing to contend with come this next year. Why? Because there have been certain things that were pushed over to fiscal year 2013 by the legislative leadership and the governor. We're going to have a little bit more to pay next year as far as the deficit is concerned, and nobody's saying anything about that. I applaud the administration for dealing with refunding the rainy day fund That's a good thing, but we need to be careful not to get all hopped up about how it's getting better because the economy hasn't quite turned the corner just yet. Going to pay some bills, and I will be back momentarily.
Fresh, organic, and homegrown. On the Horn. OnTheHorn.com.
Budwitz & Meyerjack PC is a large Connecticut-based CPA firm with offices in Cheshire and Farmington, Connecticut. Large enough to handle engagements of enterprises with annual revenues in excess of $100 million, yet small enough to cater to smaller businesses and individual clients who expect personalized attention from partners and staff. Client service is the cornerstone of our practice. Our clients have a fixed fee for their audit and tax work. What this means to the client is we're approachable. Personal communication and client services make for strong relationships. Budwitz & Meyerjack, certified public accountants.
Sandits Travel for business and leisure. We'll take you there. Sandits Travel has been proudly serving Connecticut since 1960. That's over 50 years. And we're ready for another 50 years of superior service. Whether you prefer to come in, call in, or log on, we invite you to explore how efficient, diverse, and fun it is to book through Sandits Travel. Save your money and your time with us. Sandits Travel. We'll take you there.
I hate it when, you hit, it doesn't come up. NewsTalk is also brought to you by Gateway Financial Group, as well as Sandits, which you just heard, Budwitz & Meyerjack, and one of my favorite places.
I like my biscuits nice and hot.
Deepwater Seafood of Avon. Have you been to the only fish market in Farmington? In the Farmington Valley. Deepwater is located on Route 44 and is open 6 days a week, Monday through Friday, 10 a.m. to 6:30 p.m., and Saturdays, 10 a.m. to 5 p.m. One of the best things about Deepwater is their fish are fresh. 3 deliveries daily to meet your needs. Deepwater has a menu of grilled fish items, scampi, fish and chips, soups, bisques, and chowders. For your catering needs, authentic paella, cedar plank salmon sides, and always the traditional New England clam bake. Deepwater also has the very best shrimp cocktail, and I mean the very best, that you'll find anywhere. Call in your order at 860-676-9657, and they'll have your order ready for pickup when you arrive. Deepwater Seafood of Avon, not just for the halibut. All right. I've paid enough bills for the moment. I want to get to something here. We're going back to politics. The fifth congressional district in Connecticut, the race is heating up. We're actually seeing TV ads by all 3 Democratic contenders. And we have seen at least 1, possibly 2 ads from the Republican contenders. I know I only saw Greenberg and Lisa Wilson Foley's ads from the Republican side. I'm not sure whether or not I saw anything from Rohraback or from Bernier. I think I might have seen something from Bernier, but I'm not sure. But all 3 Democratic contenders are, in fact, running. Chris Donovan and, Elizabeth Esty has come out with a very interesting ad. And Dan Roberti has also had something that if anybody's actually watched it, you might actually be kind of scared to vote for this guy. He sounds a little too eager. I don't know. Donovan's is your typical, I'm the candidate, I work for the people, and please vote for me. It's nice. Esty's is a very smart commercial, and it focuses on jobs and what can be done in Connecticut to bring jobs to Connecticut and to foster additional jobs in Connecticut. But what is interesting is something that has just come out. A women's group is targeting Donovan. This story is by Christine Stewart. A national pro-choice organization announced last week that it will target women voters in the 5th Congressional District by taking aim at Chris Donovan. Emily's List, a national organization, has thrown its support behind former Democratic State Representative Elizabeth Esty and will send more than 26,000 primary voters 8 pieces of mail. 5 of those mailers will highlight Chris Donovan's record on taxes and raising his own pay. And 3 will showcase Esty's decision to return 10% of her legislative salary and work towards responsible budgeting in the state legislature. Quote, Donovan's 20-year record for Connecticut speaks for itself. Exorbitant pay raises and the biggest tax hike in Connecticut history. Middle-class families are paying the price. Denise Feriazzi, director of the women's group Women Vote Initiative, said in a press release, Elizabeth Esty returned taxpayer money and is committed to responsible budgeting. The group said that it is not referring to the 2009 budget in its mailings, but the 2011 budget, which included the second largest tax increase in the state's history and reduced the property tax credit for those earning under $100,000 a year. However, Donovan and his campaign are not running away from his progressive credentials. Said Gabe Rosenberg, it is shocking that Elizabeth Esty's D.C. allies would resort to such misleading mailings to distract from former Representative Esty's willingness to slash health care for kids, seniors, and the poor, and cut education, including schools, in her own district, all to keep taxes low for millionaires. Gabe Rosenberg is Donovan's spokesman. Esty served in the state legislature in 2008 and 2009 and voted against the Democratic budget in 2009. Esty supported an alternative budget, which increased income taxes on couples earning $250,000 to $500,000 a year. Instead of supporting the Republican-like budget of former Representative Esty, Chris fought to protect the programs that matter to Connecticut's middle-class families by asking millionaires to pay their fair share. Those are the democratic values that Chris has always fought for and will never back away from in Congress, said the spokesman Gabe Rosenberg. He added he was referring to the 2009 budget. Donovan, Esty, and Dan Roberti of Kent will be vying for the Democratic nomination on August 14th. The seat is being vacated by U.S. Representative Chris Murphy, who is running for the U.S. Senate. What has got to make the Donovan campaign extremely happy, is that the Esty forces are not focusing on the campaign finance debacle that is still playing its way through federal court. I'm referring to the arrest of Donovan's campaign finance director, his former campaign finance director, and how there are potentially additional arrests that may be coming forth in the relative near future. That's got to make Donovan's folks real happy that Esty is not talking about that anymore. Nonetheless, you are going to be seeing things happening within the next 2 to 3 weeks. Not only is Brannigan's plea likely to be taken at some point, actually he has pled not guilty. There is going to be another pretrial hearing scheduled at the end of this month, next week, I believe, once the accused individual comes back from his brother's wedding. He was allowed out by the federal judge. And all that is going to raise once again the issue of whether or not there is a problem going on for Donovan and campaign financing. I will say, in order to be fair, that Mr. Donovan has indicated that he was never aware of where the money was coming from. He was aware that money was coming in. The problem that I have with that is that you need to know who your big donors are. as a former politician running for a 4-town position, the probate court, I can tell you I was very aware of who my campaign donors were and how much they gave. I will grant you that the 5th District has lots of towns, a lot more than the 4 that I was running for. But the federal laws are very specific about what it is that you can and cannot do. And if Speaker Donovan is going to be basically telling us, hey, I was in compliance with the law, but I really wasn't aware of what my campaign finance director was doing, I have a small problem with that. We will see what happens on August 14th. And our last little news piece is legally oriented, but it has political overtones. And that is an article by Hugh McQuaid that was posted today. And it was about a group of lawyers who are representing at least 8 of the 10 men sentenced to death in Connecticut, and the fact that they argued that the state's repeal of the death penalty is pertinent to their lawsuit, alleging the capital punishment is too arbitrary to be constitutional. The lawsuit rests on the claim that Connecticut's death sentence is imposed arbitrarily, with racial and geographic factors making certain offenders more likely to be sentenced to death. This happens to be a statistic that bears out. You will find that more people were sentenced to death in the Waterbury Judicial District than almost anywhere else. You will also find that New Haven and Fairfield come in behind Waterbury, and Hartford and New London and Windham counties barely even make a blip. The lawsuit is being dealt with on a pretrial basis at the Rockville Superior Court. And in Rockville Court this morning, a team of lawyers argued that Judge Samuel Sverza, easy for me to say, Sverza, should allow them to amend their complaint to account for the legislature's appeal of the death penalty for future offenders. In other words, they had filed their complaint before the state legislature repealed and the governor signed the repeal into law, the repeal of the death penalty. Attorney David Golub said the prospective nature of the new law made the death sentence even more arbitrary because it allows some offenders to be executed while precluding other offenders guilty of similar crimes simply because of the date that the crimes were committed. Said Golub, if I commit a crime on Monday, I get the death penalty. If I commit the same crime on Tuesday, I do not, Golub said. It doesn't make sense. What he's referring to is the folks that commit a crime, a capital crime now, are not going to be sent to death row. They are going to be imprisoned for life without the possibility of parole. Whereas folks who were convicted before the legislature stepped in, and that would include the infamous Stephen Hayes and his sidekick, who are the last 2 fellows to be sentenced to death. Komorsiewski, there we go. And it was because of Hayes and Komorsiewski that several legislators were very squishy about voting in favor of the appeal. Getting back to the complaint, lawyers from the Chief State's Attorney's Office asked the judge to deny the request to change the lawsuit. Assistant State's Attorney Michael Proto said that rendering illegal the death sentences of the inmates already set to be executed was not the lawmakers' intent when they passed the bill back in April. Proto said that the legislative enactment was not within the parameters of what the court was tasked with addressing. He said that amending the complaint would add more delays in a case where delay is already inevitable. In terms of litigation, this is a Mack truck, not a Maserati. It doesn't stop on a dime, he said. Golub said that he and the other lawyers representing inmates were surprised that the state was objecting to the amendment. He said that the alternative is that his client, Cedric Cobb, and every other death row inmate will file a new separate petition tomorrow to reflect the repeal. How does that make sense, he said. The judge will have to rule on whether the lawsuit can be amended sometime before the case leads to trial in September. The state plans to conduct the trial at Northern Correctional Institution, where the death row inmates are housed. It will be broadcast live at the Rockville Courthouse for the public. This is fairly unusual, and there aren't that many judges that I know of who would willingly step into the precincts of Northern Correctional. Judge Severaza, there we go, is a much braver man than I. The fate of the men already sentenced to death was a prominent concern as the new law was being debated in the legislature. Some supporters, like Democrat Senator Edith Prague, only voted for the bill on the explicit assurance that it would not impact the executions of those already sentenced. Excuse me. I'm fully prepared to vote for repeal with the caveat that I stand up on the floor and get documentation from the chair of the Judiciary Committee that this in no way gives judges any discretion to apply this repeal to the people who are currently on death row, Prague said back in April. When it came time to vote, Prague got that assurance, but opponents maintained the prospective nature of the law wouldn't pass constitutional muster, and in the end would result with the courts scrapping the executions of the 10 men currently sentenced to death. That's a decision that will be decided in the courts, Senate Republican leader John McKinney said. No one disputes that there will be a legal challenge brought by the Public Defender's Office, and the weight of the legal experts is to say that a prospective death penalty won't pass constitutional muster. It will be some time before that issue is decided. Golub said that lawyers for the inmates hope to get the issue before the state Supreme Court as soon as possible. Ultimately, we all know that it's going to be decided by the Connecticut Supreme Court, he told the judge Tuesday. Well, that's kind of interesting because effectively, Attorney Golub was saying that Judge Severa's decision wasn't going to matter because it was going to be in front of the state Supreme Court anyways. That's usually not considered to be a winning legal argument. Nonetheless, what is interesting is whether or not you have a situation that is tenable as far as the state Supreme Court is concerned. What was told to Senator Prague was correct. The language of the statute specifically precluded those inmates already sentenced to death. And therefore, if the repeal passed, the way that the language of the law was, it would not prevent those already being sentenced to death from being executed. What was not fully explained, shall we say, to the legislators who were voting back in April was that the constitutional argument about equal protection, not only what you would find in the state constitution, but also the federal constitution, might preclude having one inmate executed and another not. So, for all intents and purposes, Attorney Golub's conversation with the judge today was fairly accurate. This is something that the Supreme Court is going to have to decide. But if Judge Safazera was to rule that the law was unconstitutional, the question that I would have is whether or not the governor would require the state's attorney's office to actually appeal all the way up. And there is a mechanism, by the way, where the appellate court could be bypassed because you are dealing with an issue of such constitutional magnitude. Life, liberty, and property are the three things that are protected by both the United States Constitution and the state constitution. And since we are talking about life here, that's going to be given a constitutional prerogative that will vault it up over the appellate court and directly into the laps of the state Supreme Court. The real question is going to be whether or not it is decided before the next gubernatorial election. That is not so certain, because in all likelihood, the state Supreme Court is going to require both the defendants and the prosecutors, the state's attorneys, to write extensive legal briefs as to their positions to show why the law was either, as it is to be applied, unconstitutional or not. And it's pretty clear that the defendants are in a kind of hinky situation. Why? Because they don't necessarily want to repeal the death penalty, which is what could happen with, repeal of the death penalty, which is what would happen if the law was found to be unconstitutional. But they also don't want to get executed. Shock, shock, surprise, surprise. So it's going to be a legal tightwire act that we're going to be seeing over the next several months. And the September trial in Northern Correctional Facility is just going to be the beginning of the circus. Tune in. We will be following this. I am highly interested in this, having been practicing law for 23 years. Well, folks.
Can
go
I
ahead.
interrupt?
By all means. Hello, Chris Didden.
Hello there. I'm sorry, but were you just talking about the death penalty?
I was indeed.
In Connecticut?
In Connecticut, yes.
And since we don't have, we don't quasi have a death penalty in Connecticut, correct?
Well, in a sense, we don't, but we still do.
That's why I'm saying quasi, because, technically, by law, we still do.
The new guys can't get juiced. The old guys
can get juiced. Right.
That's it in a nutshell.
So what happens there? So we've got to figure out, the legislature's got to figure that out, right?
No, it's going to be the courts.
It's going to be the courts?
What they're going to have to decide is whether or not the preclusion of the repeal as to the 10 inmates currently on death row
applies to them or doesn't apply.
Whether or not it is constitutional under the Equal Protection Clause of both the United States Constitution and the state constitution is in fact constitutional.
And unfortunately, I think they're going to lean that way.
Well,
just because first of all, Connecticut's never been a real liberal state when it comes to the Constitution.
Actually, we're one of the bluest of blue states in the country at the moment.
Per se, but not necessarily in our values.
Not necessarily as far as the death penalty, which is interesting because 63% of the Connecticut citizenry still support the death penalty.
Absolutely.
There was a majority, over 50%, who said that they were okay with repealing the death penalty now, as long as we ice the guys that were still on death row. That was one of those, that was the compromise they came up with.
And unfortunately, you're looking at the guy right now. The two main guys on death row that everybody's talking about are the, Pettit murder guys.
Yep, Stephen Hayes and.
I don't even mention their names anymore. I don't even really give them the time of day anymore because
I understand that.
But
they're the main reason why there was a compromise in the repeal law.
Right.
Because originally the Democratic leaders wanted to repeal the entire damn thing.
Right. But they didn't want to tick off the population.
So they came up with a compromise.
They came up with a compromise in that process, which is amazing because, unfortunately, that's unconstitutional.
There's a pretty strong argument that way. We will see about that. Tune in more as we will follow that. What I'm going to do is I'm going to back out of here.
Thank you.
No, well, you're more than welcome, Chris. We are going to be hopping to our next show in about 15 minutes, actually a little less. But you've been listening to News Talk Tonight. I'm Dave Moore, and I thank you for watching, for listening, and furthermore, I want you to tune in to WTNF, which will be coming on at 8:15. News Talk Tonight has been brought to you by Amazon.com, Gateway Financial Group, Sandits Travel, Sherpa Technologies, Budwoods and Meyer Jack CPAs, Deepwater Seafood of Avon, and CentralCTDental.com. I'm Dave Moore, and I'll see you next week. Take care.